All right, it's 4. So for those of you who are joining us today, thank you. Good afternoon. Today's webinar is presented by the Detroit chapter of the Turnaround Management Association, and we will be discussing bankruptcy from the secured lender's perspective. Before I start, I want to thank all of our sponsors, our chapter executive, and especially the panelists for agreeing to join this panel and all of the hard work that they did getting the content together. I'm Noel Ravenscroft, and I will be the moderator for today's webinar. I'm an associate attorney at Bodman, and my primary practice group is the bankruptcy, debtor-creditor rights, and the related litigation that comes along. If each of the panelists would like to introduce themselves, Jacob, would you like to kick us off?
Sure. Jacob Villemure, worked at Comerica Bank for 20 years, 17 of those in our special assets or collections department. Had the pleasure of working 9 of those 17 years with another panelist, Shareef Simaika. I'm also a TMA member, and I have a CTP certificate.
Thank you, Jacob. Shareef?
Thanks, Noel. I'm Shareef Simaika. I'm with Amherst Partners in our restructuring practice. I began my career as an analyst at Comerica, and then I was in special assets, as Jacob said, for almost a decade, and then went on to various roles in commercial credit, including middle market, sponsor finance, small business, and private lending, and then made the transition to consulting a little more than 4 years ago, and have represented debtors, secured lenders, and automakers on distressed supplier engagements.
Thank you, Shareef. Last but not least, Bob?
Thanks, Noel. I'm Bob Diehl, a partner at Bodman, in chair of our banking and bankruptcy practice groups. I won't say for how long I have practiced, but the year I started, the prime rate peaked at over 20%. So that's a hint. My role on the panel today is counsel to the secured creditor. Thank
you, Bob. Before we dive into bankruptcy, I want to discuss some of the pre-bankruptcy considerations. Shareef, what are some of the common reasons that a borrower files for bankruptcy?
So I think the most common reason is going to be that they were forced by the secured lender. And when I say forced, I don't mean in the legal sense. I mean that the relationship with the lender has gotten to the point where the lender's not willing to provide any more funding, any more forbearance, any more accommodations. They've gone as far as they're willing to go, and don't leave the debtor with really any other choice. So other common reasons would be a litigation of some kind or another, whether it's an enforcement action by vendors or a judgment creditor of some kind. That's a common reason. Also as a means to effect a distressed sale through a 363 process. If you've got creditor disputes or other reasons why a buyer is really concerned about getting clear title and wants the bankruptcy process, wants the cleansing provided by the bankruptcy process. Less common, at least in middle market arrangements, but still factors are if you have leases you want to reject or other contracts that are unprofitable that you want to reject. Or also in some cases, you want to be in a position you can set aside or avoid a preference payment of some kind. Those are the most common reasons you're going to find, especially with middle market borrowers.
And Jacob, how do secured lenders perceive the bankruptcy process?
Well, no, it is it's a process. So a secured lender's perspective is going to be based on the role it plays in that process, the risk it faces in that process, and its desired outcomes. Bankruptcy certainly has a more clearly defined set of rules. It's also typically, compared to alternatives such as out-of-court restructuring, receiverships, or assignment for the benefit of creditors, is typically slower, usually comes with higher costs. I will say in any one of those scenarios, it's very important for a bank to surround itself with seasoned subject matter experts, whether it be legal or business consultants such as panelists.
Now I want to set the stage for a little bit, most of our presentation here. So for most of our discussion, the audience should assume that the borrower has a working capital loan, equipment loan, and or a real estate loan from this particular lender, and that the credit facilities are secured by all assets of the borrower. They're cross-defaulted, cross-collateralized. In the bankruptcy context, Bob, how do personal guarantees change this lender-debtor dynamic?
I think that they can change the dynamic dramatically. First, is the guarantee limited or unlimited? Is it collateralized or not? If it's unsecured, is the guarantor collectible? A guarantee by the principal can take a lot of the fun out of the bankruptcy for the debtor and its principal.
Now, while we're talking about this relationship and the dynamic, Shareef, how does the relationship between the borrower and the lender affect this process also?
Yeah, it affects it a great deal. So if you've got a cooperative situation, and that can mean a pre-pack, a formal pre-pack, or it can just mean a situation where the debtor is filed and there's a plan, a path to move forward, and the bank's on board, and maybe they've worked out those details in advance, or maybe they're just doing it as they go. But in any event, if the bank is supportive, then a great deal of what we're going to talk about here today ends up not really being an issue. On the other hand, if the bank is not supportive, you've got an uncooperative borrower, or one that's been adverse to the bank, or perhaps they haven't been negotiating in good faith pre-petition, or pursuing a strategy that the bank's not supportive of, or threatening litigation against the bank, or there doesn't appear to be a clear path to an outcome that's going to be favorable, at least to the secured lender, I should say. Any of those situations, the bank may not agree with whatever the debtor is proposing, and it needs to consider what the alternatives are. But you're going to have a lot of things that get contested that we can talk about as we go on today.
And when a lender knows that a bankruptcy filing is imminent, Jacob, what can a lender do to pre-plan for that?
Yeah, great question. Obviously, there's several things you could do, time being of the essence. You want to, in addition to selecting counsel and possibly a financial consultant, you'd want to determine your exposure, re-familiarize yourself with your loan documents, and understand any related items such as treasury management products, swaps, corporate cards, and just try to see the entire scope of relationship that is likely to be examined in the case.
For majority of this discussion now that follows, we can assume that the borrower debtor now has filed a Chapter 11 petition in bankruptcy. Bob, what are some of the initial bankruptcy concepts that a lender must consider when the petition's filed?
Well, I think we'll just start with the automatic stay, which is a concept that's familiar to everybody in the seminar, I'm sure. But we want to take 1 minute just to talk about involuntary cases. And those are interesting because the involuntary does also cause the automatic stay to be implemented, but the debtor is not constrained by Section 363 the way it would be in a Chapter 11. Involuntary cases really are a limbo. If the putative debtor is ultimately adjudicated a debtor, as is typically the case, the date of the petition, the involuntary petition, is the petition date, and any transactions that occur after that date can be scrutinized as post-petition transfers. So from the secured lender standpoint, we're generally speaking uncomfortable with that limbo period, and we'll want the debtor to get into bankruptcy so that the case can proceed with the normal structure. Separate from that, obviously, when the case is filed, it's time to engage with the debtor, if you have not already, on financing, sale, reorganization. And of course, within days, the committee will be on the job as well.
And Jacob, Bob mentions the automatic stay. What are some of the steps that a lender must do to prevent stay violations?
Well, administratively, from the first day of filing, the lender would want to take whatever steps are necessary to ensure that the bank accounts often held at the same institution as the secured lender have appropriate controls in place to prevent, for example, checks clearing by putting a hold on the account, stopping things such as auto charge functions for loan payments until such a time as the court rules otherwise.
Now, in the bankruptcy context, Jacob, what's a lender's primary goal?
Well, in most bankruptcy cases, the lender's goal is to recover on its loan, its investment, as quick as possible while preserving its position throughout the process. That involves kind of identifying what strategic path, which Bob just kind of outlined, is most advantageous to achieving that goal within the rules of the bankruptcy code. But at the end of the day, most secured lenders didn't sign up to make a loan that would end up in bankruptcy. So they're really looking for the fastest resolution with the least amount of risk.
Now, one of the initial considerations of a borrower who has now filed for bankruptcy is how to fund its operations, either through reorganization or to get to the sale process. And debtors typically do this through the use of cash collateral or through debt financing. And by contrast, one of the principal questions for a lender at this stage of the case is whether it should consent to the use of cash collateral or if it should fund the debt. Earlier, Shareef highlighted the differences between a cooperative and uncooperative debtor-lender relationship. And I think this is echoed pretty much throughout the bankruptcy process. With that backdrop, Jacob, assuming a cooperative lender-debtor relationship, what is a lender looking for before it consents to the use of cash collateral?
Sure. In the context of a reorganization, it would be very similar to underwriting a loan, whether it be at origination or an amendment. Is there sufficient security and, most importantly, a clear path to reorganization, and do prior relationships and performance show that the debtor is willing and able to be able to execute? When talking about a sale from that context, again, also sufficient security. You want to pay close attention to any collateral deterioration, and you may, as a secured lender, accept some nominal deterioration if the purpose is to bridge to a sale that is satisfactory to you.
Now, assuming the opposite, right? We have an uncooperative debtor-borrower relationship. Jacob, when would a lender typically oppose the use of cash collateral?
Those situations certainly unique to the case, but anytime it feels that the adequate protection or diminution was perhaps not being characterized in a manner that was consistent with how the secured lender views it. We, for example, maintaining some level of formula on an asset-based revolving line of credit. If the company had a prior track record, the debtor that is, had a prior track record of proposing and failing to perform on reorganizations, restructurings outside of court, that would be another thing that a lender would potentially take issue if the goal of the debtor was to, try to reorganize for the maybe fourth, fifth, or sixth time.
So
Shareef, what are your some thoughts and comments on this?
yeah, I was gonna say, so it's important to note that the secured lender and the debtor very often will have different views on the same set of data. So that the debtor is going to claim that replacement liens or what have you are going to be more than sufficient to cover whatever cash collateral is being utilized. And the secured lender is going to look at those same numbers and argue differently. They might apply a formula differently. They're going to argue that we would argue that some of it's not collectible. There are a lot of things you can argue, that you can argue the same set of data differently. And I think it's important for a lender to think through these things early on, because the earlier, as a secured lender, you understand where you stand, what arguments can be made, how things are likely to look, the better positioned you are to affect the outcome and to get the case moving in the direction you want it to move, or at least closer to it.
Bob, do you have thoughts, comments on this also?
Yes, I think that in general, the negotiations over use of cash collateral are very fluid, and it's hard to diagram a single game plan to deal with those negotiations. Certainly, the secured lender has to adjust depending on the interim hearing on use of cash collateral. It's almost impossible for the debtor to lose at the initial hearing with respect to amounts required to avoid immediate irreparable harm. But once again, it's not necessarily in the secured lender's interest to consent at the interim hearing if a longer-term deal is not in place. At the final hearing, both sides are under considerable pressure to negotiate a consensual deal. A secured creditor is going to get better protection under a consensual order prepared by counsel. It's going to have milestones, it's going to have covenants, it's going to have a formula. It's going to create a framework by which the debtor can be judged. If the order is entered over the secured lender's objection, you're typically not going to have those bells and whistles. Instead, you're going to have the adequate protection offered by the debtor or ordered by the court, and you may end up relying on your super priority administrative expense under 507B. One observation: if there is a big difference between the secured lender's perception of the case versus the debtor, sometimes it's strategic to object. Not because you're going to win at the interim hearing or even at the final hearing, but at future hearings when extensions are requested. And one observation too, with a non-consensual order, typically the secured lender is unhappy, but that also means that professionals have to be uneasy because there are no approved budgets or carve-outs for their fees.
Those are great points. And Shareef, there's also a large part of this analysis is whether the lender is over or under secured, and what does that really mean for the lender at this stage?
Yeah, so I mean, simply put, if you're oversecured, the value of your collateral is greater than the debtor's obligations to you, and that's a good thing, because as a secured lender, you're entitled to interest payments, you're entitled to professional fees, at least to the extent that there's enough of a cushion to pay those things. If you're undersecured, I think that's pretty self-explanatory. It means you don't get the interest and the professional fees. You're entitled only to adequate protection. And the key for a secured lender is, ideally, we want to be right on the cusp, because we want to be able to argue that any deterioration is detrimental to us. And that's important if we're contesting use of cash collateral or what have you. But we still want to be entitled to our interest and fees, and so that's just an area where you have to be careful of what you want to show, what you want to claim as far as how well secured you are.
Right, and Shareef, you brought up a good point about adequate protection. Bob, do you have any comments on this?
Yeah, just starting with the whole valuation question. Valuation is typically not obvious at the start of the case. Even if the debtor and the secured lender want to stipulate that the lender is oversecured, the committee is going to have some input into that ultimately. And in many cases, certainly cases where sale is the ultimate objective, the valuation of the collateral will ultimately be tested by that sale process. As Shareef said, in a perfect world, you've got a cushion sufficient that you can justify current payments. But in the real world, there's always going to be some uncertainty and some risk that payments that are received can be recharacterized and applied to the secured portion of what ultimately might be an undersecured claim. When we talked about adequate protection, and we'll talk a little bit about that more, but the code talks about it being the indubitable equivalent. And from a secured lender's standpoint, what is typically offered is found wanting. Cash is one thing. Margined accounts receivable and inventory, sure. That's certainly something that middle market lenders are accustomed to accepting. But there are sometimes second or third liens and other types of collateral that really are not valuable from a typical secured lender's perspective.
Jacob, Shareef, any further comments on that?
As far as just to identify potential forms of adequate protection, often it would be in the form of cash. So sometimes equal to depreciation tied to the asset being used, or loan payments tied to a specific loan. Another alternative, as Bob touched on, is kind of replacement collateral, whether it be newly pledged or post-petition replacement liens. Either one of those, could be considered that form of economic rent.
So, and this can be a, go ahead, sorry.
Sorry, no, I was just going to add that sometimes some atypical things can get offered that a lender shouldn't be too quick to dismiss, and it's often worth taking the time just to think through. Maybe it can work. That's all I was going to add.
Yeah, and this can be really a highly contentious process at the point of the case, right? And you really need the use of experts to really kind of drill this down. Shareef, what are some of the tools of your trade that could help a lender during this process?
So, yeah, I mean, I alluded to this earlier, that the senior lender and debtor can argue opposing views with the same, usually have the same starting data, although sometimes even that can be up for debate. It's really the analysis of that data and forecasts going forward that ultimately lead to different conclusions. And so underwriting or analyzing budgets, cash flows, especially in an adequate protection argument, that's going to be crucial. Liquidation analysis for whether you're arguing with someone's, if you're over or undersecured, adequate protection, indubitable equivalent, all those concepts, you're going to need a baseline for those things. You're often going to need valuations, whether it's the business as an operating entity, the fixed assets, inventory. You often need to get appraised, real estate, IP. There are a lot of different things, and whoever has the best information the soonest, as I said, I think is in the best position to negotiate. And a lot of times that means really doing your due diligence as a secured lender on what the debtor's presenting. Sometimes it means doing our own for the secured lender. And it does make a difference. And I mean, obviously, if you've got a contested, excuse me, if you have a contested matter, that may end up coming out in court in the form of expert witness testimony, or it might be, later on in a deposition or something like that. But the real action to me is out of court. It's when everyone's in the hallway, or it's when the judge will typically say, how about we take a half-hour recess and you go try to figure it out. And that horse trading, the more you know and the better position you are to make your argument, the more likely that the debtor is going to say, maybe we should agree to a compromise. So to me, being prepared for that is really critical.
Thank you. And now if there's no further comments, I'll switch gears now to a debtor that's requesting DIP financing. Jacob, what are some of the key considerations that a lender must decide when determining whether to provide that or oppose the use of DIP financing?
Well, much like when the use of cash collateral is presented in front of the lender at the onset of the case, you know, does the funding of DIP financing provide you with adequate, controls over your collateral, but also does it take you down a path that you want to go, and that ends up resulting in an outcome using whatever a sale process, for example, does that take the secured lender to the place it would like to go, which is to normally collect on its loan in full? However, there are other, certain things that lenders need to be prepared to react to as it relates to the long-term impact of potentially not funding the DIP loan.
And Bob, what are some of your thoughts on DIP financing?
Well, one of my mentors way back in the day said, if there's going to be DIP financing, I'm going to be the one to do it. But of course, what that means is if he doesn't want to do it, then he doesn't want anyone else to do it. And so there are some technical priming points. For example, sometimes a lender will prime itself. But what we're really talking here about a situation where the debtor tries to prime the secured creditor on a non-consensual basis. And that's never going to be acceptable because it shifts the risk to the pre-petition secured lender and gives the first position to the priming lender. Typically, that it's going to occur where the debtor asserts that there's a substantial equity cushion and that is sufficient to protect the pre-petition lender. And of course, what gives the lie to that from a secured lender's perspective is if there really was an adequate equity cushion, a new lender could be brought in a second position and rely on that equity cushion. So it is, you also occasionally will have a debtor who alleges a temporary need, a need for bulge financing that's going to create value and allow that loan to be repaid. In my experience, non-consensual priming liens are frequently threatened. They're litigated occasionally, but only rarely approved. There really is not an active market for priming lenders in the middle market space. The loans are too small. The maturities are too quick. There's not enough money to be made for there to be a tremendously active market. So sometimes when you have a priming fight, it's sort of a friends and family type lender, which should put the bankruptcy court on guard with respect to the appropriateness of the proposed priming loan.
And now you've mentioned a few times the unsecured creditors committee. Bob, what are some of the dynamics between the lender and the committee throughout this process?
Well, there's always going to be a tension between the committee and the secured lender. That's particularly true when the secured lender did not want the bankruptcy case filed. The traditional argument is, hey, this is part of the process. You've got to pay for it. And of course, that's true, but it's a harsh truth when you didn't want the bankruptcy filed. But really, the ground rules between the secured lender and the committee are fairly well established. There's got to be some sort of a budget for their efforts. They're going to have to review the secured lender's position, identify preferences, if any. They're going to review any stipulations that the debtor has made with the secured creditor, and generally participate in the process. Where there's risk, trying to negotiate a carve out and sometimes trying to add value, but creating tension there with the debtor and the secured creditor if that involves slowing down a sale process, for example, because of the risks that are involved there, particularly if there are losses that are being funded during that period.
So as we work through the bankruptcy process kind of chronologically, for this segment of the discussion, we can assume that a debtor either has their cash collateral order in place, DIP financing, and as Bob has explained, there's some clear paths that a debtor is going to head towards, reorganization, a sale, refinance, or some sort of combination. So starting with a debtor that's proposing a sale as opposed to reorganization, Shareef, from your perspective as a consultant, what are some of the areas that you focus your attention on when reviewing the proposed sale and even the sale process?
So I think it has to start with the process. And I'm going to assume that this is a sale of a business as a ongoing concern, not, effectively an orderly asset liquidation in bankruptcy. So I want to know how's the company being marketed? Do they have a qualified investment banker involved? Do they have experience in that industry if it's a special industry? Do they have experience in distressed situations? With respect to the auction process, is this a naked auction or a stalking horse? What milestones are being assumed for things like getting an LOI, purchase agreement, so on, proposed breakup fees, all those kind of things. How is a qualified buyer being defined? Is there a potential buyer or buyers already identified? What do we know about them? Is this going to be a cash sale? Are these folks, is it going to be contingent on financing for the buyer? And basically, it's all trying to identify from the bank's perspective how likely they are to succeed, they being the debtor, to succeed in getting the sale done, and what is the likely cost of funding the debtor to get to a sale between whatever operating losses they have, professional fees, so on. And the bank the secured lender needs to do its diligence on all those things and basically underwrite the probability of execution and a result that's better than the alternative, which in and of itself is often a theoretical. The secured lender is generally going to compare that to where they are right now if you could do a orderly liquidation. But in a bankruptcy, it's not your call as a secured lender. You can push for that, but that's going to be an uphill battle in most cases. So just trying to balance how hard to push, what to agree to, what not to. That's the calculus that you're doing as a secured lender.
Jacob, what are some of your thoughts on this?
Well, I think Shareef covered a lot of the execution risks that are faced also outside of bankruptcy or in other court processes. A secured lender would do itself good to include, milestones such as delivery of executed letters of intent from qualified purchasers, followed by purchase agreements and close within the proposed time. Secured lenders would usually take comfort in the stalking horse bidder, as it knows that it has at least one offer when compared to a more traditional approach through an investment banker. There's some other things. Would a secured lender, as part of trying to do a sale, consider a sale of its own position vis-a-vis a credit bid? And those are kind of unique to the circumstances. But obviously, from a secured lender's perspective, they're once again just looking for the most certainty to maximize recovery on their investment and maintaining as much control, often through funding the debtor in possession loan, to achieve that desired outcome.
Bob, you have some thoughts on this?
Yeah, no, just a couple. Just to emphasize that when we talk about the sale milestones, those are milestones that we would have integrated into the cash collateral order or the financing order, so that if one of them is, if there's a default in any one of those milestones, it gives the secured lender the ability to revisit the strategic plan going forward. And also, just to elaborate on the credit bidding issue, that's sometimes an issue with the stalking horse bidder, where they want the lender to agree that it will not exercise its right to credit bid. And at first blush, you might say, well, hey, a typical middle market lender, I'm talking about an institutional lender, would not be interested in credit bidding. So is that an issue or not? And to Jacob's point, it becomes an issue potentially in terms of foregoing potential opportunities, because sometimes a competitive bidder, rather than proceeding directly, will want to buy the secured creditor's loan as a means of credit bidding. So it's not the institutional lender, it's the loan purchaser that exercises that right. That's particularly true in a situation where the loan is undersecured and where the loan purchaser is trying to buy the loan at a discount, but potentially be able to use the purchase loan at par for bidding purposes.
Great points. And before we move on to our next segment, we actually have a question from one of our attendees. And they write, during several of their 363 prepackaged bankruptcies, keeping critical vendors in line while appeasing other unsecured creditors has been always an issue. So what are some of our thoughts on appeasing critical vendors before you get to the sale period?
Maybe I'll start and then let others join in. The real tension there is in cases where the trade is not going to be paid in full. And that's stating the obvious, but you've got cases that have proceeded where the trade is not going to be impacted. So whether it's a prepackaged plan, or at least the current trade vendors are not going to be impacted. And so in that situation, they can be given essential supplier treatment and protected, and that's the treatment that they're ultimately going to get. So it's really just a prepayment of the treatment that they're going to get in either the sale when those contracts are assumed, or in the reorganization process when they're paid. But in other cases, the tension is manifest, because every payment that goes to an essential supplier is potentially diluting the unsecured recovery. Unless you have secured creditors who are undersecured, and then it's really diluting their recovery because they're the ones that are funding those essential payments. So it's the situation where there's going to be a pool for unsecured creditors, and the pool is diluted by the essential supplier payments that the committee has to, I think, be very proactive in making sure that those payments really are essential to allow the going concern sale or reorganization to occur.
It's a great question. Any other thoughts from the other panelists on this?
I'll throw out there, as Bob mentioned, if the secured lender is undersecured, or if they think they're undersecured, even if they've argued that they're not, if they think that they are, then it is in fact potentially coming out of their ultimate recovery. And then for the secured lender, it's just a question of what do they think is in their best interest. So if we're talking about a situation where the secured lender was never supportive of whatever path the debtor is on in the first place, they might be even more loath to see that go through because it dilutes their position, and they might want to, at that point, we might be, as a secured lender, you're trying to argue along with the rest of the unsecured or anyone else who's objecting otherwise, if you're sold on whatever the path is, then that's something you're going to want to see happen. And in some cases, you may even be willing to agree to some kind of a carve out to make up for it. But it just depends on the circumstance.
Yeah, great question. Okay, so we were earlier talking about a proposed sale. So now moving on to kind of a traditional Chapter 11 plan of reorganization. Shareef, how does your analysis change in that context?
Yeah, so in many ways, it's very similar to what we talked about in the sale process, except now instead of underwriting the likelihood of reaching a conclusion and how much you're likely to realize from that, now as a secured lender, you're basically being asked to stay in, and from their perspective, it's like a new loan application. Would you stay in? Would you do this proposed loan ordinarily? And almost always the answer is no. So the second question is, well, is it better than the alternative? And from there, often the answer is yes. So with that, it's just a question of, again, what does it take to get there? How much in funding? How much worse? How much more risk? What is the likelihood that they can execute on their plan? So you're trying to underwrite viability of the reorganized debtor, cash flow, ability to service debt, and so on. And a lot of that has to do with whatever the original problems were that led them into bankruptcy. Have those been resolved? Are those addressed? And I think the real challenge to the lender is that the vast majority of the time, if there's a loan in special assets, for example, if there's a troubled loan, management was part of the problem. And if management is still in place and still running the company, that really gives you a lot of pause as to whether or not you want to stay in it. Now, if you've gotten rid of a whole bunch of debt in the process, maybe it works, but those are all things you want to consider, and ultimately, how quickly do you end up getting paid off with the reorganized debtor? Is it something you think can get refinanced? And really, it all boils down to what's your alternative, though. If it's better than the alternative, the secured lender is going to will be supportive, and if they don't feel that way, then it's a lot harder to get them behind you.
Bob, I'm going to throw you a compound question, which relates to our next section, but it's also a question from the audience. So in this one, we wanted to kind of focus in on what are some of the key sections of a Chapter 11 plan that you kind of focus on. And one of the questions from the audience, which is related, is your opinions of filing under the new Chapter 5.
Okay, with respect to the new Chapter 5, I'll start with that. I think that that is a very interesting opportunity for debtors that qualify. And of course, the dollar limit on those, which was originally $2,725,000, was temporarily increased to $7.5 million.
Yep.
And so that creates a much larger opportunity for debtors. And sorry to committee counsel out there, but there's no committee. And because there's no committee, expenses would typically be lower. Only the debtor can file a plan, so there's not an exclusivity concern. The absolute priority rule is not applicable. And so for a debtor where the principal intends to maintain ownership, that is a really important consideration. In addition to better from the debtor's perspective, voting rules. So there are some, nothing's perfect, but I think that any debtor who would qualify for that chapter would have to strongly consider it. Now, to the other part of the question, and sort of going back to this whole plan process, clearly at this point in the bankruptcy, at best, the relationship between the debtor and the bank is strained or fatigued. And so when the plan is being proposed with the secured lenders staying in post confirmation, normally that's because the debtor can't find a refinancing source. And so if the debtor can't find a refinancing source, by definition, the existing lender is probably not going to be happy with the package. Now, that doesn't mean that you can't work out a deal and have a consensual plan, based on that deal. It's no different than what we talked about in the context of a cash collateral or a financing order. Certainty is important. And so a consensual deal is sometimes better than the risk associated with a non-consensual deal. And from a secured lender's standpoint, cram down has a meaning to everyone in bankruptcy, but cram has a different meaning to secured lenders. And so we use that acronym to stand for collateral, rate, amortization, and maturity. And those are the four most important things to any secured lender. And unfortunately, from the secured lender perspective, all of those items are at risk in a non-consensual plan. The debtor can propose changes to collateral, rate, amortization, and maturity. And so that is why there is a real tension and an impetus to try to reach a consensual deal as opposed to litigating those issues. There's been a lot of litigation over plan financing terms, and it can be expensive. And as I said, there's a lot of risk. One other observation about the plan process, in a situation where the lender is undersecured and where that unsecured piece is substantial, and where the recovery to unsecured creditors, or at least to the class that the secured lender is assigned, is de minimis, the secured lender has to consider an 1111B election, which is, and this is, a complicated area of the code, and so I'm probably going to give it a little bit of less detail than it deserves. But essentially, that's an election by the secured lender to have its entire claim treated as secured. So you forego whatever distribution you would receive on account of what would have been your unsecured claim. There is a strategy associated with 1111B. I think that the most frequent time when you would want to consider using it is in a situation where the collateral, your collateral, has been valued, in your view, unfairly lowly. And so where you think that valuation is unfairly low, or even if it's fair, you think it's low because of a temporary phenomena. You know what I mean? If it's an oil and gas asset and oil and gas is at $30 and you think it's going to 60, well, the fair valuation of your asset at 30 is a lot different than at 60 or 90. And not predicting that oil is going up, but just using that as an illustration of where valuation can change rapidly based on underlying phenomena. And so that's something that has to be considered where the lender is undersecured.
And Shareef, one of the earlier things that you discussed was a borrower may file for bankruptcy to set aside or avoid a preference. And traditionally, people probably think of, more of a vendor or trade creditor being paid within that 90-day preference period. However, Jacob, what are some of the preference risks that a secured lender may face?
Well, perhaps the reason a debtor filed was a recent negotiation with its secured creditor may have resulted in the pledge of a a large valuable piece of collateral. And in those circumstances, secured lenders always have to be cognizant of that risk for the preceding 90 days and would again want to ensure that the deal that they bargained for was going to provide that collateral, because it would be certainly frustrating to negotiate a very difficult workout or forbearance agreement only to provide that consideration for the collateral, only to have it taken away within 3 months. So when secured lenders are often negotiating their workouts, you have to consider many, many things, and what the alternative could be for taking perhaps a very, might be viewed as the debtor as an aggressive position. Again, all the more reason to, for secured lenders in distressed situations with distressed loans to get a lot of feedback from different areas, whether it be legal as it relates to the code or business professional from turnaround consultants such as Shareef.
Bob, what are some of the other preference considerations that you think of in this?
Well, just to focus on maybe a couple of issues that may not be as obvious. Under 547, you do have the protection for floating liens, working capital liens on inventory and accounts, but there is a limit to that protection. There can be a preference if there's been an improvement in position with respect to an undersecured creditor. And that's not common. Typically in the 90 days before the bankruptcy case, working capital degrades. And so it's not that often that there will be an improvement in position. But there are times when that there is. And typically that is when there is a substantial trade credit being provided, substantial new inventory being provided, which improves the secured creditor's position and potentially could lead to a preference exposure with respect to that improvement. And the other thing that I'll mention, because it's along the same lines, although not technically a preference, is exposure under 553 if the secured creditor has set off a bank account prior to the bankruptcy. And there again, there's an improvement in position test. And that code provision really was implemented from a policy standpoint to discourage set-offs, because set-offs frequently can be a precipitating event, a precipitating cause of a bankruptcy. And so if you set off and that causes the bankruptcy, depending on whether you were undersecured and whether there was an improvement in position, you can be exposed and have to disgorge some or all of that set-off.
So we have another question from the audience. So do we see a significant increase in bankruptcy filings in 2021? And if so, what chapter, 5, 7, 11, or 13s?
I'd say all of the above, but maybe we can take a panel vote. I think that the wave hasn't happened yet. I think that the PPP loans were a substantial mitigating factor. I think that some of the other loan programs, the EIDL loans and other SBA programs have been a mitigating factor. Loan deferrals by the loan payments by the SBA and loan deferrals by middle market lenders have also put off the day of reckoning. But on the other hand, if you're a restaurant, you're a bar, you're a gym, you're a bowling alley, you're a dry cleaners, there's so many businesses that are impaired and will continue to be impaired until the world gets back to normal, if it ever does. So I think that there's got to be a deluge of those cases. And I think a number of them will fit into the Chapter 5, the new small business Chapter 5 slot.
I'll just tack onto that. I have 3 clients, debtors that all or were pursuing sales in a distressed situation, and all three of which are today in a better position with respect to liquidity. These are all out of court. They all have better liquidity today than they did in February. And not one of them would have made it past June if it weren't for the PPP funds. So the PPP, it's really hard to overstate how much impact it had in deferring that day of reckoning that Bob mentioned.
And I would say in the manufacturing sector, it may not have just deferred it, it may actually have avoided it, because there are a number of manufacturing companies with the PPP bridge and with the current level of manufacturing activity are doing just fine.
Yeah, one observation from a secured lender perspective is everything that Bob and Shareef just touched on are really focused on what might be characterized as a balance sheet restructuring. I think one of the keys unknowns or variables to answer that question will be revenues. Will revenues come back? Because no matter how you structure the balance sheet restructuring, and operational restructuring requires some level of continuation of top line revenue, whether it's growth or maintenance, beyond just traditional cost cutting measures. So those operational turnarounds, are potentially hanging the balance.
And I think that's probably a great spot for us to stop. We're bumping up against the clock as well. So again, I want to thank all of our sponsors, the panelists. This was a great discussion. And for those of you that are not members of TMA, I would encourage you to check out the website and join. There will be a 30-minute networking session that'll start immediately after this presentation. There's a link that's going to be put in there by Amanda in the chat function of Zoom, and it should be in the middle of your invite in your email. So I would encourage anyone that wants to participate, click the link and join. But thank you again. I hope you enjoyed the presentation and enjoy the rest of your evening. Thank you.
Thank you.
Thank you.
Thank you.